Hello.
Hi, Amanda. Good morning.
Hey, how are you?
Good. How are you doing?
Can't complain.
That's good. Staying warm, I hope.
I am. Isn't it just amazing, like just the change?
So fast. Surprises me every year. All right. Well, I think we'll go ahead and get started. My name is Adam Goss. I'm a project manager with Mental Health Colorado. I'll be filling in for Vincent this morning. He is tied up with some behavioral health task force work this morning, so he sends his apologies. But we'll go ahead with our Disentangling Mental Health and Criminal Justice Reports and Updates meeting. We'll have a little bit of a continuation of last month's presentation from the Colorado Department of Human Services. So we are joined this morning by Amanda Edwards with the Forensic Services team, and she'll be speaking to us a little bit about court services and competency evaluations. So with that, I will pass it over to Amanda. And as far as questions, we'll give her a little bit of time just to present, and then following her presentation, we'll encourage people to participate, come off mute, ask questions, but feel free to enter any questions into the chat if something comes up throughout her presentation. So go ahead, Amanda. Thanks.
Thanks, Adam. I appreciate it. And thanks, everyone, for inviting us. We really appreciate the partnerships and making these connections. So as Adam said, I'm the Director of Court Services. So my essential function is I oversee our forensic evaluators throughout the state of Colorado. Right now, we have 32 full-time evaluators and then 2 half-time evaluators that work with us. And we also have 36 contract evaluators that work with us throughout the state of Colorado. In order to be an evaluator in Colorado, you have to retain a licensure. And we also are only allowed to practice within the state of Colorado. And this is usually a question I get, so I thought I would hit that one right up front. Because of the licensure issues and because of the client safety, that we only practice within the state of Colorado. And this is including our video conferencing evaluations or any evaluations that we're going to be when we're using any kind of technology or teletherapy. Sorry, I'm stumbling on my words. So that question I get quite a bit. With our with our forensic doctors, they have to retain their license, and they test and do licensure throughout the year. They also do up to 40 plus hours of forensic evaluation training, any trainings and statutes. And then we also have monthly meetings. Each of our evaluators has a peer mentor that they work with. And so they're trying to stay up on real-time information. One of the other questions I get with about forensic evaluators is, so if someone has mental health issues or has substance issues, would that automatically make the person incompetent to proceed? And what our evaluators are looking at is really, does the person understand the court proceedings? We very much are unbiased in the legal system. So we really want to look at like, what's the best possible situation for our clients whenever we're meeting with them. And so to go into that, I apologize that I'm going to inundate you with statistics, but I was told that this is a statistics group. So right now in the state of Colorado, we have 2,259 court orders that are for either competency evaluation, restoration evaluations, or mental or sanity evaluations. And those are primarily the type of evaluations we do. Within those evaluations, we will address mental health issues, we will address substance issues, but the primary goal is, again, to make sure that we're providing a well-balanced, informed report to the courts of, is this person competent to proceed or not? And if they're not, what would be the best possible location to provide these services? The services we provide would be in the locations of within our county jails. And right now, most of our court orders are within the county jails. So of our active orders for the month of August, we had 375 total orders, of which 187 were within our county jails. And of that, 53% of those clients were found incompetent to proceed. Our largest districts given referrals are the 2nd, the 4th, the 18th, and the 1st. And of those 187, 58.7% come of our referrals. So over half of those referrals come from those 4 districts. So again, that's the 2nd, the 4th, the 18th, and the 1st. Prior to COVID, our restoration rates were 49.7 that were incompetent to proceed, and that was right in line with the national average. We have seen an uptick with incompetent to proceed based on COVID. So what we're doing is once we get that incompetent to proceed, then the person is, when admissions is occurring, they're being admitted to either the hospital, where they'll do inpatient restoration treatment. We do have contracts for our jail-based restoration programs with certain jails, and they'll receive restoration treatment there. And then we have our community restoration partners throughout the state of Colorado. So we're looking for really that risk, need, and responsivity when we're doing that initial competency evaluation, and we're trying to find the best possible location for the person. And to be clear, when we're doing a competency evaluation, the evaluation is not necessarily a risk assessment. And a lot of times the courts are asking us to do that. Although there is some crossover, really our goal again is just to make sure that the person is getting the level of care they need. And when we're looking at the risk, that happens a little bit, but we really rely on our other partners, for example, pretrial, the district attorney, the attorneys in the case to really, and then our forensic navigators to really basically come back in and say, hey, this person's appropriate for the community or this person's not. When it's a tier situation or the person really escalates to the level they need inpatient care, we will make that recommendation to the court and we'll ask that the person be placed into the hospital immediately or as soon as the hospital can potentially get that person admitted. So that's really our involvement as far as what competency is. And so I don't know if there's any other questions for me, but that's basically our job. It's really provide an opinion of either competent to proceed or not competent to proceed, work with our community partners, and then try to provide the evaluations to the court as soon and as timely as possible to make sure that people aren't waiting longer than necessary to receive those competency services. Questions, comments, or concerns?
I had one question. I've heard that you've had a pretty significant increase in the number of individuals for an evaluation, for an ITP evaluation, and that the state is now behind on those as far as the timelines go. Is that accurate?
For
information?
Absolutely, ITP evaluations. And so are you talking about the the evaluation where someone was actually deemed incompetent to proceed and then they're waiting for admissions into the hospital? Or are we talking about the initial competency evaluation where where would be the first time that they were actually receiving services from my department? Because both of yes, I mean, but there are circumstances.
Yeah, I think it's they've had an order to see for an evaluation and they're waiting for the evaluation, the initial one.
Yep, this is correct. And so I initially reported out. So to give you a little bit of context on this, we've in the last 4 months, we've actually seen a record number of court orders and jail ordered evaluations. Prior to last month, our average for jail evaluations was between 80 and 90 clients waiting to receive services. We have a time frame of 21 days, and we've consistently hit that 21-day timeline from August of last year until August of this year. However, this month, we hit a record number of 187 evaluations, and we do have approximately 10 cases that were over the consent decree timeline. Some of those issues were just a lack of resources. We just didn't have the bandwidth with the evaluators to be able to complete that. The other issues were that there were several jails that had outbreaks of COVID again. And so the person wasn't able to complete the evaluation because they were in isolation or quarantine. And then the other issues were that the folks were just refusing to do the evaluations. And so we reached back out to the court and see if the court could assist us with that. Hopefully that, Lauren, hopefully that answered your question.
Yeah, that's helpful. Thank you.
So for when the evaluation occurs, so we actually, the initial competency evaluation when the person's in jail, and that is where the majority of our evaluations are taking place right now, it's 21 days. So from the time that we actually get the collateral until we turn it into the court is 21 days. Usually the evaluator will have it to their administrative assistant by day 19. Previously, we were hitting that deadline, but like we were just talking about with Lauren, this month has been a little tricky in getting the evaluations done on time. We are out of compliance with approximately 10 evaluations.
Thank you. That was my question. If it's okay, can I jump in with another one?
Absolutely.
Okay. What happens if the court rejects the findings?
Traditionally, if the court rejects it, it would go to a second opinion evaluator. So a private person would come in and do the evaluation process again and either agree with our opinion or find something different. And then at that point, the court makes the decision to either accept the opinion of the second evaluator, or we've actually seen it where they've even had us do a third opinion evaluation where we've actually gone in and done it again. And the other thing that the courts are doing, which is hard on our department, is they're rejecting the actual findings themselves, and then they're just reordering a new competency evaluation. And that's also one of the reasons why we're seeing an uptick as well.
Okay, thank you. And I don't know a lot about this topic, but we're looking at a sort of jail study right now with our population. So I'm curious, what is the capacity for the inpatient care if a person is found to be incompetent and then referred to that type of care? Is there excess capacity? Are we overcapacitated in the state at the state level? Do you know?
So right now, the prognosis is pretty grim, to be frank. The hospital was started out with being hit really hard with COVID. And then they had to do there's maintenance and there's a lot of reconstruction going on, and then also staffing. So right now, if someone is considered a tier 2 or not, wouldn't what we'd call escalate to a tier 1 level where they would need immediate admittance, they're staying on a wait list. The average time for the wait list right now is anywhere between 60 days to 90 days, depending on the location and again depending on the acuity level. Our forensic navigators are in the jails, in most of our jails, and they're actually telling the hospital, basically saying, hey, you need to look at this one first, or we really need to consider some kind of resources for this person. But there is definitely a huge backlog, and I can give you that number too, because I thought that question might come up. So right now there's currently 350 people on the wait list that need services that escalate to the hospital level.
Great, thanks, I appreciate that.
sorry, this is Lauren. I guess I just wanted to add one more comment or question. Robert, in a recent report out on the competency wait list, said that 2 individuals actually died by suicide while waiting on the wait list. Is there any kind of specific support? Are those people on tier 1, or is, I guess what lessons learned do we have from those deaths? And then also a breakdown from what Sonja said about misdemeanors versus felonies, and what those breakouts are for people on the wait list.
Yeah, honestly, Lauren, that's a great question. And so that's probably a question that should escalate to the admissions team. And so and I don't want to answer on behalf of them. And I know that they do have protocols in place, and that they definitely take every situation serious. But I can tell you on the misdemeanor side, which we have some good news. We just did a big data poll, and we're working with the district attorneys for all the different judicial districts. And what they've just asked me to do is provide them the either lower level felony cases and misdemeanor cases throughout their district. And they're going to go through, and on that 350 wait list, to see what cases can be dismissed, or see what cases that we could potentially move or do something different with, so they're not sitting there waiting for services. Any other questions? You guys are actually letting me off pretty easy.
I have another question. Sorry, can you hear me? So I'm in Texas, and we're doing similar things. Our wait list is way more. But for those that we're running into the issue of, okay, we're going to dismiss, but the person does actually need inpatient care. And so the question is still a capacity issue. So how are you all addressing that?
There's a process right now, and they're actually working on trying to retain contacts for civil beds for those specific type of cases. I think they're in final phases, and hopefully within the next couple of weeks, we'll actually see some movement with that. And that question's come up quite a bit. And also additionally, like what clients can actually go into outpatient restoration. There's a lot of work from our forensic navigators to see if we can get people into those outpatient services first, and try to do that continuity of care of see if they are successful in outpatient. And if that's not an option, then maybe something in the middle, like looking at something, a situation where it's potentially where it's like we've even discussed like working with our halfway houses to do something that's similar to the community corrections. And then the third level would be where they really truly need that inpatient level of care.
Amanda, this is Linda Isenhart. I'm one of the county commissioners up in Gilpin County, and our jail does serve a variety of inmates, as everybody else does. But it occurs to me that 60 to 90 days waiting if somebody needs to have inpatient services, that's really hard when they're in crises. And I'm wondering what our local jails can do. I know that there's counselors and that kind of thing, but if someone is truly in crises, what can we do?
Lyndon, I don't know if you work well with your forensic navigator. I would definitely suggest reaching out to the navigator, and so they can look at doing some potential like holds if need be, or also like looking at different resources. And some of the crisis situation is really just a matter of what we've experienced is people with substance issues, people that need back on medications that aren't taking their medications, or folks that actually have TBIs or traumatic brain injuries. So we were kind of experiencing that, and we also believe that's some of the upticks that we're seeing. But that would be what I would suggest, is that talk to the forensic navigator about the situation, and also they can escalate it up to the hospital so that they can say, hey, you really need to look at this person. They've definitely had a change in acuity, and we're worried about them.
All right, good. Thank you. We do work with Jefferson Center for Mental Health, and we're up in the mountains. We're a small county, and they do provide some services. So I'll follow that advice and follow up on it. Thank you.
Mhm.
I have another question if nobody else is going, because you just mentioned something that we keep touching on here and then nothing gets done, which is the TBI. So what is the conversation around TBI? Because I know the last meeting that this group had, someone was actually talking about housing persons with TBI was the most difficult thing that they were experiencing in diversion, that they couldn't maintain housing. So what is the conversation about what should happen with that population that hits that acuity a lot?
So our conversation has been really looking at it at the front end level and seeing what we can do prior to, like, what we've been talking about, and kind of one of our proposals out is like almost even at the arrest level. So rather than escalating and trying to fix stuff on the back end, we're really working on trying to find resources to fix things on the front end. And if it truly is a some kind of brain injury or dementia, then we need to like some kind of assessment up front to look at that. And then the next issue is we talk a lot where we see a lot of overlap with our substance abuse, our chronic substance use clients, and then with mental health issues, and then those folks that just do great on medication, and then when they're off medication. And so that's been the conversations that we're having because again, and so the evaluators are pretty a linear, like solo focus. So once we get that court order, our job is really to determine competent or not competent. And so honestly, our bandwidth, if we were to remain to have 375 total evaluations a month, we wouldn't be able to do it. I mean, we wouldn't be able to meet our deadlines and records. And I would feel bad for the admissions teams because they would, that would just be completely out of control. So what we're trying to do is really like push and like kind of work with our partners about getting those services. And one of the things we have a judicial work group, and we work with some of our judges of talking about if they have that bandwidth, or even having people up front to do those assessments so we get those services immediately. And then even like one of the other things we were talking about yesterday is getting those services right at the arrest level so that it's not escalating into a jail/crisis situation.
Amanda, this is Neil. Talking from my University of Denver perspective, I've been meaning to talk to you and Catherine Davis and other people at OBH. The university has a lot of resources when it comes to assessment for TBI and planning for treatment recommendations and that sort of thing. And it's one of those things that that I've been sitting on, and I just have backburnered it. But if it would be useful to the department or to the outpatient competency restoration providers to have kind of at their back pocket an on-call TBI assessment protocol done, I think we could probably work that out pretty easily so that, a lot of people who are in outpatient restoration have cognitive disabilities and TBI kind of histories. And sometimes a thorough assessment on those kind of issues can be helpful when it comes to treatment and restoration. So maybe we can talk more about how that could be supportive or helpful to the department and the restoration program.
That'd be great. No, thank you.
Mm-hmm.
And hello.
Yes, hello.
Amanda, I'm wondering if you, from a systems perspective, what levers would you pull to make things work more smoothly? Where would you invest more or increase our capacity? What would be your top?
That's actually a really good question. And obviously this is just an opinion. And it's definitely not on behalf of OBH, but it goes back to what I was just saying. I've worked in criminal justice for a lot of years. I've worked on the other side of it, and I've worked within probation and parole and stuff too. But it always seems like everything's expected to be fixed on the back end. And I've seen that the same bandwidth, the same where people intend and do a really good job until they just get to that capacity where they can't meet clients, and they can't give everyone really the services they need. So really that upfront stuff, and kind of like what Neil was talking about, I mean, I'd really like to see like really be able to have the time to sit down and like work with clients like right up front at any level of entering the criminal justice system to see if it really truly is someone that needs to be in the system, or if we can divert them to other resources right away. And I think that would help a lot, and not even just for on the mental health side. I think that would help with, on the other side, I think it would help with the overpopulation in our jails, the overpopulation in our prisons, the overpopulation on people on probation. And I think that we'd really truly focus on those people that need services. And then the other thing is housing and resources. Like, we just need to have that money to have those community resources, and an understanding of the folks in our community, and that it's basically a community issue and not just a singular issue with certain people. Obviously, opinion only.
Thank you.
All right, does anyone else have any thoughts or questions for Amanda?
If you do, please feel free to reach out to me. I'll put my information in the chat. I'll be more than happy to answer questions or to talk about any other issues or concerns you have. Because like I said, I really appreciate the partnerships and relationships.
It's like Sonja asked a question, if anyone on the group knows how many forensic navigators are in Colorado.
I do.
Awesome.
There's currently 17 right now, and they're in the works of hiring a contract evaluator, or not evaluator, excuse me, navigator.
All right, well, we do have a little bit more time left allocated here, so I'd like to just kind of open the floor up. If anyone else has any updates that they'd like to share with the group on any work that they're currently doing, feel free to pull yourself off mute and share.
I can go. Hi, this is Lauren Snyder with Mental Health Colorado. We have 3 different bills that we're working on for this next legislative session. 2 of the bills we have recommended that the Mental Health Disorders and the Criminal and Juvenile Justice Oversight Committee draft and run this session. So it's not 100% sure that they're going to be running those, but they are being drafted right now. The first actually deals with individuals who are in the incompetent to proceed process. We've learned a lot from changes from the last couple of years of legislation, and have some cleanups. So some of the main things that we're hoping to address in this legislation is the timelines that are set for dismissal of charges only apply to people who are in custody. So people basically in receiving inpatient restoration services. We are hoping to change legislation so that those dismissal timelines apply to people who are on outpatient restoration services as well as a lot of the required, every 90 days. So evaluations, that just making it very clear in statute that those every 90-day evaluations should apply to people who are on outpatient competency restoration as well. We also are trying to clarify the practice of moving somebody from the criminal justice system to the civil system. How it's written in statute right now doesn't really follow or jive with our it's called 2765, so Title 27, Article 65. That is our civil commitment laws. They don't really jive together as well as they could. And so just being very clear that the court can really initiate those those certification processes at any time to have somebody evaluated for a certification, with the hope that, if they feel better that an individual can be certified and get treatment on the civil side, that they're more likely to dismiss charges or get that person into potentially an outpatient setting where they can get medications, albeit potentially forced medications, that they can be out of jail receiving those services. We've also had a lot of issues that we've heard about around bond and people who have been ordered to inpatient or in custody evaluations. So in custody or inpatient evaluations or inpatient restoration. And so we have just tried to make it very clear and given more opportunities for the court to reassess bond and bond status given that order and their likelihood of doing well in jail, given our timelines right now. So just clarifying that basically if somebody has an inpatient restoration order, that does not prohibit them from being eligible for bond, that those two are different, and that bond eligibility supersedes an inpatient order or an in custody evaluation order. So that's our incompetent to proceed bill. We're also working on a not guilty by reason of insanity bill. And basically right now in statute, anybody who's found not guilty by reason of insanity is automatically placed in the custody of the Department of Human Services and automatically go to SIMHIP, taking up beds there. We know that individuals who may be very sick at the time that they committed a crime, by the time they're actually adjudicated, they may be on medication, stabilized and doing well. And so making sure that somebody doesn't have to go to an inpatient setting right as soon as they've been adjudicated of not guilty by reason of insanity, that they could actually go to a community placement and placed on, just basically go to community. So allowing for that, not requiring, but allowing. And then also a few other things around not guilty by reason of insanity. Right now, you can be found not guilty by reason of insanity and be confined forever, when if you were found guilty, there would be maximum timeframes that you can be in prison for those crimes. And so just adding some limits on how long somebody can be confined if found not guilty by reason of insanity, to be more in line with what they would be less 50% or 30%, depending on the crime, if they're found guilty. Does that make sense for folks? And then the last one is just a mandated court review every 2 years to make sure that an inpatient placement for a person found not guilty by reason of insanity is appropriate, so that we're continuously reviewing, saying, is inpatient the best place for you? Do you meet these standards? If not, let's get you into the community. In our mind, not only is this beneficial for that individual, but also frees up a lot of potentially many beds at SIMHIP that could otherwise be used by people who really need that level of care. Okay, and I'll be done quickly, I'm sorry. So the third bill that we're working on that does interact with this is Mental Health Colorado and the Office of Behavioral Health are collaborating on a pretty significant bill to rewrite our civil commitment laws in Colorado. So that includes our transportation hold, where you can transport somebody up to 6 hours if they appear to have a mental health condition, to then be evaluated for an M1 hold or 72-hour mental health hold. We are rewriting the M1 hold statute, the short-term certification statute, as well as the long-term certification statute. It's a gigantic bill, but our hope is that we can change some of these processes to better serve individuals and make it a more effective process. So that's a lot, but thanks for your time and allowing me to give you an overview of what we're doing this year.
Thanks, Lauren. Thank you for sharing. So if nobody else has any thoughts or questions about our upcoming bill, oh, Neil, go ahead.
Yeah, you shouldn't open the floor just for people to talk. Is a mistake. So, Lauren, it's great to hear about those different initiatives. I'm sorry I joined the call late. Amanda, if you already said this, I apologize for repeating it. But if you did, it bears repeating. You know, the special master, one of the two special masters for the oversight of the transformation of the competency services system here in Colorado, and I've been working with the department and the other parties involved for a few years, and it's never been worse. I can say that. The wait list is longer than ever. The wait times are longer than ever. However, the department is not singularly to blame for this. And I just want to make sure that people understand the department really has had their hands tied because of the pandemic, because of some regulation and licensing limitations on what they can, who they're allowed to let into the hospital, and how often they're able to let folks into the hospital, how many at a time. There's just been a lot of setbacks that are beyond the control of the department. So while sometimes the department is an easy target when things are bad, I want to underscore that the department has certainly could have done some things differently along the way, but they're not singularly at fault for what's going on. In fact, I think most of the delays that we're seeing now are beyond the control of the department. When pre-COVID, the consent decree was working, timeframes were coming down, wait list numbers were coming down, everything was working. COVID really upended everything. And so maybe this isn't appropriate, but always just putting a plug in for vaccinations and good hygiene and trying to get this pandemic really behind us as best we can so we can make sensible decisions for those people who are caught in the forensic mental health system. But just want to make sure that the department gets some kudos here because they really have been hustling and working hard throughout all of these changing situations and circumstances to do the best that they can for the people that they're serving.
Absolutely. Thank you. Appreciate you offering that perspective, Neil. And with that, if no one else has anything to share, we'll go ahead and wrap up. Thank you so much, Amanda, for presenting to us today on this important subject matter. And thank you everyone for just participating and joining us for our Disentangling Mental Health and Criminal Justice continued presentation work. And we'll go ahead and reconvene next month on the third Thursday going forward. That'll be our regular time. I'll plan to go ahead and send calendar invites going forward just so it's on everybody's calendar and a little bit less confusing for us all. So with that, thank you so much. I hope you guys have a great rest of your week and stay safe and take care.
Thank you. Take care.
Thank you.